Welcome to SENDiass4BCP's webinar on annual reviews. Today we will be looking at what is an annual review and when is one held, the law and steps for an annual review, possible outcomes, resolving a dispute, and where to access some further support should you need it. The annual review is the statutory process of looking at the needs, provision and outcomes specified in an education, health and care plan by assessing the progress made and deciding whether any of these need to change. This is to ensure it stays up to date and continues to provide the support the child or young person needs. Understanding what an EHC plan contains will help you prepare for an annual review. Our webinar on checking an EHC plan may help you with this. The local authority must complete the first review of the child or young person's EHC plan within 12 months of the EHC plan being finalised. Any subsequent reviews must be completed within 12 months of the previous review. As we will explain later on, this is for the annual review process to complete, which does not end at the time of the annual review meeting itself. There are 3 occasions where an annual review may be called. This could be a review which, as already mentioned, is held due to the requirement of reviewing the plan once every 12 months. There may also be an early or emergency annual review. This may be because of a change of circumstances, a significant change of need, or because of a potential breakdown in the child or young person's placement. The other occasion when it may be called early would be because of a phase transfer review. This is when a child is in the year prior to transferring to a new stage of education, such as primary to secondary school or to post-16 education. These reviews come with their own statutory deadlines by when the annual review process must be completed. These are by the 31st of March for those transferring to post-16 education, or by the 15th of February for those transferring to other stages of education the following September. If a young person is moving from one post-16 provision to another, the deadline for this is within 5 months of the transfer. So for the annual review process to be completed by these deadlines, annual review meetings should take place in the autumn term of the academic year prior to the transfer. With this being said, the statutory process for each type of review remains the same. As previously mentioned, the process for an annual review is statutory. This means that the processes are set out in law and therefore must be followed. This is reflected in a number of pieces of legislation and guidance. The legal requirements for annual reviews, including when one should be held, the conduct of the review and amending the plan following a review, are found within the Special Educational Needs and Disabilities Regulations 2014, Regulations 18 to 22, or Regulations 29 to 31 with regards to ceasing an EHC plan. There is also statutory guidance for local authorities, schools and colleges, which is found within the SEND Code of Practice 2015, paragraphs 9.166 to 9.185 for reviewing an EHC plan, and 9.193 to 9.210 for amending or ceasing the plan. The following steps must take place in an annual review. Firstly, you, the child or young person, school or institution, and any professionals involved must be consulted and views sought. This information must then be circulated to all parties no sooner than 2 weeks before the annual review meeting. You and your child or the young person may be asked to complete a form to gather your views as part of this. We have another webinar available on parent, carer and child contributions which you may find useful. An annual review meeting must then take place to discuss the EHC plan. We will discuss this in more detail a little later on. After the meeting, a report of what happened must be written and sent to everyone who went to the meeting or provided information to be discussed. You are then provided with an opportunity to ensure it is an accurate account of the meeting itself. You should advise the producer of the report, usually the school or college, if you would like to make any amendments. You will then provide your consent to share this information with the local authority, which must be done within 2 weeks of the meeting being held. Following this, the local authority then review the information and make a decision. We will discuss this more later on. Recent case law states that if the local authority decide amendments are needed, then they must send you the draft amendments along with the decision notice. This must be received within 4 weeks of the annual review meeting and concludes the annual review process. The final plan following this must then be received within 12 weeks of the annual review meeting. IPSI provide a useful annual review checklist. A link to this can be found on the annual review page of our website. When preparing for the annual review meeting, there are some things you may wish to consider in order to make it as productive as possible. Firstly, read the EHC plan. Is it reflective of your child or the young person as things are now? Highlight and make note of anything you feel is not accurate or anything you are not sure of. You may wish to seek any updated information from professionals involved, especially if things have changed or indeed if any progress has been made. You may wish to invite them to the meeting if they have not been invited already, or you may wish to take a friend to help you take notes during the meeting, so be sure to let the meeting organiser know. Complete your views. As previously mentioned, you may find our webinar on parent, carer and child contributions useful, or you can contact us should you require any further support. If the annual review is for a young person who is 16 years of age or above, then you will require their consent to contribute to the meeting. Complete views with your child or the young person. The educational setting may offer to do this, but sometimes children and young people can present differently and provide different views with different people. It may be useful to ask an impartial third party to support you with this. You can ask us for support with this if you need to. There may be circumstances in which you would want to consider requesting a personal budget. Please see our webinar on personal budgets and direct payments, or further information on our website. Remember to share these with the meeting organiser no less than 2 weeks prior to the meeting, so everyone has a good understanding of the viewpoints as well as any concerns which may need to be addressed. The format of an annual review meeting may differ slightly depending on the setting, but the following should be discussed as part of the process of the annual review meeting. The child or young person may have contributed their views prior to the meeting, and in addition, they may or may not wish to attend either some or all of the meeting itself. But it's important their voice is still heard, as the review, of course, is about them. The child or young person should remain to be the central focus of the meeting. As a result of your views and/or that of your child or young person, amendments may need to be made to Section A of the EHC plan to ensure it remains up to date and accurate. The child or young person's progress towards outcomes and whether the outcomes remain appropriate for them will be discussed. The outcomes may require changing. If they have been achieved or if they need to be changed, the local authority should amend the EHC plan with new outcomes. It is important that they are SMART. That is, they are specific, measurable, achievable, realistic, and time-bound. Any new identified strengths and needs will be discussed. This may also lead to amendments being made to the plan. If you have previously identified anything which you feel to be inaccurate or outdated, or indeed anything new, then you can discuss this at the meeting and request information is amended or removed. There may be further discussion around this also, and amendments made to Section B of the EHC plan. The child or young person's provisions in Section F will also be reviewed. This is particularly important if it has been identified that expected progress is not being made in some areas. Provisions should be specific and quantified, and Section F should reflect any additional support which has been put in place to support the child or young person. In addition to what is discussed in the annual review meeting, any new reports provided from professionals will also be considered when making any amendments to the EHC plan if needed. If the child is in Year 9 or above, it will also be considered what provision is required to assist the child or young person in preparation for adulthood and independent living. This is a legal duty found in Regulations 20 and 21 of the SEND Regulations 2014. The SEND Code of Practice also states that for teenagers, preparation for adult life needs to be an explicit element of their planning and support. Discussions about their future should focus on what they want to achieve and the best way to support them to achieve. It also includes some examples of what this may include. That is, support to prepare for higher education and/or employment, training options such as supported internships, apprenticeships and traineeships, support in finding a job and learning how to do a job, for example, through work experience opportunities or the use of job coaches, help in understanding any welfare benefits that might be available when in work, preparation for independent living, including where the child or young person wants to live in the future, who they want to live with, and what support they will need. Considering local housing options, including housing benefits and social care support available. Support in maintaining good health in adult life, and support in participating in society. This is a wide-reaching concept and includes such things as understanding how to get about, using transport and benefits options relating to this, and making and maintaining relationships. There may be very good reasons to start planning for adulthood sooner than Year 9, and the code suggests that it can be helpful for EHC plan reviews before Year 9 to have this focus too. We do again have further information on our website with regards to this, including a webinar which you may find useful. As when your child or the young person was first issued with an EHC plan, and as every part of the plan is open to be amended following the annual review, you have the right to request that a particular school or college is named in the final EHC plan. This could be the current school or college, or you may wish to consider naming a different placement. This right applies to the following types of school: a maintained school or nursery, either mainstream or specialist, an academy, an institution in the further education sector, a non-maintained special school, or a Section 41 school or college. The local authority has to prove that at least one of these conditions applies in order to dislodge the parent or young person's preference. This does not apply if you are requesting a wholly independent school. However, there is other legislation which you can rely upon with regards to this. The only reason the local authority can refuse the request is if the setting is unsuitable for the age, ability, aptitude, or special educational needs of the child or young person, or the attendance of the child or young person would be incompatible with the provision of efficient education for others, or the attendance of the child or young person would be incompatible with the efficient use of resources. In order to evidence one of these reasons, your parental preference must be consulted with first. In accordance with Section 9 of the Education Act 1996, the local authority shall have regard to the general principle that pupils are to be educated in accordance with the wishes of their parents, so far as that is compatible with the provision of efficient instruction and training, and the avoidance of unreasonable public expenditure. So, just because your preference of school is more expensive, it would have to be unreasonably more expensive in order for the local authority to not consider naming it. Case law considers a cost of £2,000 to £4,000 to not be considered as unreasonable. Following the meeting, within 2 weeks, the meeting organiser will prepare and circulate to all invitees the written report setting out the recommendations on any amendments to be made to the EHC plan. Any difference between those recommendations and recommendations of others attending the meeting, and all the information and advice obtained about the child or young person. The local authority will then be required to make one of 3 decisions within 4 weeks of the meeting. To maintain the plan means the local authority feel no amendments are needed to the EHC plan. Therefore, no changes will be made and everything will remain the same until the time of the next review, when this will be reviewed again. The EHC plan will be finalised and sent with the decision to maintain the plan, along with your appeal rights, within 4 weeks of the annual review meeting. To cease the plan, the local authority can only cease to maintain the EHC plan if either it has found out that the young person does not wish to return to education or training at any setting, or it has concluded that returning to education or training would not be appropriate for the young person. This is set out in Regulation 30 of the SEND Regulations 2014. Provision must not stop immediately, and provision must remain in place until the right of appeal expires, or until an appeal has concluded. If being appealed, the plan can only cease if a tribunal orders it. To amend the plan, amendments may be made to any sections of the plan, including the placement named. In accordance with case law, the local authority's proposed amendments must be sent at the same time as the decision letter. You must be provided with a minimum of 15 days to provide your representations on the plan, before it is then finalised within 12 weeks of the annual review meeting, considering your written representations. A draft plan will not include the naming of the school or institution to be named. This will be completed on the final plan only. Following any decision made, following the annual review meeting, you will have a right to appeal. It is the letter which details the decision of the local authority to maintain or cease or amend that provides you with this right. Appealable decisions following an annual review are amendments to Section B, the child or young person's needs, amendments to Section F, the provisions specified for the child or young person, Section I, the placement named in the EHC plan, or a cease to maintain decision where the local authority intend on ending the EHC plan. For most appeals, you are firstly required to consider mediation, and you should do this within 2 months on the date of the decision letter. Details regarding this will be on the decision letter itself. We have lots of information with regards to appeals on our website, and you may find our webinar on mediation useful, as this also includes the option of early dispute resolution with BCP Council. If you require any further support with an appeal, then please do get in touch. If you require any further support with regards to an annual review, then you can visit our website, SENDiass4BCP.org, where you will find lots of free resources to support you. You can email help@SENDiass4BCP.org, or you can contact our advice line, open Monday to Thursday, 9:30 till 12:30.